This year has been full of the highest highs and the lowest lows of my life, and I see so many women around afraid to speak right now, afraid to share their experiences, and fear is by design. It's what keeps us silent. But I also acknowledge that many people don't have the opportunity to speak, so I do feel fortunate that I've been able to. And it's the women who have had the ability to use their voice that's kept me strong and helped me in my belief in my fight for the world to be safer for women and girls. It's a pretty simple thing.
Welcome back to my channel. Blake Lively's new film, Another Simple Favor, was released yesterday on Amazon Prime straight to streaming, and there's been a lot of headlines. She appeared on Seth Meyers last night, and not without consequence. She made a public statement regarding her legal lawsuit with JustinBaldoni, and when I say not without consequence, is that anything that she says publicly will be used against her in court, and one of accusations against her is that she is conducting a smear campaign on Baldoni to blemish his reputation and ruin him and to essentially gain the rights to a movie. It starts with us. I don't really understand what her ultimate goal is anymore. I just found it kind of strange that she employed her kids to parlay the start of this video. She essentially stated, "I'm leaning on my kids now, they're my only source, blah blah blah. It's been a very rough year." And then Seth was like, "Oh, since you said that, would you like to say something?" It was very rehearsed, and then she gave that very rehearsed statement to Seth, claiming to be a spokesperson for all women, but she's not. And Blake Lively's narcissism was on full display in the Seth Meyers interview. And I'm of the belief that people that are like Ryan and Blake, they can't help themselves. It's not any different than Ryan Reynolds appearing at Green Day's Hollywood Walk of Fame star ceremony, making an 8-minute speech that was essentially all about him. And he said almost next to nothing about Green Day, and he just recently met them a year ago or 2 years ago when he was filming Deadpool and Wolverine. It was just a really strange ad that he would be there. And it sort of felt like maybe he's the reason they received the star, because I don't know why he was there, but he turned their moment into him. And Blake made that moment about her victimness and martyrdom. You know, covert narcissists love to be the martyr. They love to play the victim, and they love to manipulate people through sympathy. So here's the thing. Blake Lively and Ryan Reynolds are deceiving the public today, and Blake Lively's latest film is horrible, utterly horrible. I endured it since I have Amazon Prime, and it is offered free for Amazon Prime viewers. And because it was on the house, I viewed it, and it was awful. The plot was all over the map. It did not make any sense. I could not determine why Stephanie would even be in Capri and Blake, who maintains that she is the co-star. She hardly appears. The film, I was amazed at how much she wasn't in the film. But in the film, she sues Anna into oblivion for using her name and likeness. She employs threats of lawsuits a lot in this movie, and she says she wants to destroy people. And I have no idea when these lines were inserted, if it was during post-production when Paul added in the Into Oblivion section, but I just feel like if you're under suit and you are literally the recipient of a $400 million suit, you probably shouldn't say things like that. I don't know why they do things like this. I don't either way. The movie is awful. But you know what's the worst thing about this movie? Blake has 2 characters. She plays Emily and Charity, and they're sisters. They're triplet sisters, so they're identical triplets. And their other sister she offed in the last movie. So Emily and Charity are in this movie, and the other one is missing. And Charity obviously didn't die at birth and was adopted by some woman who's her Aunt Linda. And Charity is mentally disabled and obviously is in love with Blake. And at the end of the movie, Charity bondles Blake while she's been drugged, and it's disgusting. So it's Blake doing this to Blake, even though it's like a body double. It's just gross, and it's like no one in the media is discussing that scene. No one there discussing this movie, like it's just this wonderful thing, and I'm like, this is what we're viewing in 2025, incest, gross, Paul Feige, gross. And this book, this sequel isn't based on a book. This was a script penned by Paul Gross, and she said that Justin was attempting to include obscene material into the film. I did notice in this movie that Blake did not truly have any nude scenes, and that is most likely by intent. And the only time that she was cuddling with anyone was herself. And I also observed that when she was going to be marrying her husband in this movie, it was actually because she was the beard for her secretly gay husband. There was a lot of references here. I just felt like, what are they doing here? Are they mocking that they think Ryan is gay? I don't know, I think that her actual hands are in this script way more than Paul Feig would like to admit, but in the middle of her taunting Baldoni and taunting him through the Seth Meyers, adding to the smear campaign with the Seth Meyers interview, the taunting in the real movie, these are not the behaviors of a person who's been sexually harassed, and victims of these things don't act this way. And this is a person that I think is so entitled and using her platform to continue destroying and annihilating Baldoni, and I don't think she's going to ever stop, because to her she wants to be the advocate. But it's just strange because she had the chance to make a statement back in last August for domestic violence, and she didn't speak up. And now all of a sudden, she wants to be the voice for women when she had a chance last August. Why wasn't she a voice then? Why is she a voice now? It's disingenuous, and it's clearly a manipulation to try to flip and project and deflect. And I think what's the most disappointing for me, at least as I've been seeing this unfold in the media, is I am someone who has been battling the lack of transparency from the legacy media for decades. One of the reasons I began reporting on Sister Wives and doing it in a way where I was exposing the truth about polygamy was because I was so upset with the way the mainstream media reported on polygamy. I was upset with how they reported on Cody and treated it like this is normal, and they behaved as though it wasn't a cult and there wasn't abuse. I was furious at how the Duggars were presented with this platform when they were a member of this nefarious cult, and they were selling these very abusive, atrocious practices, which damage women and children, and I'm just so fed up of the being gaslit by these Hollywood individuals who have no conscience and don't care about what they're spreading, and it's just getting increasingly more obvious to me that there's a reason why so many people are not watching or consuming mainstream media. It's because they pander to people that are narcissistic, abusive, and they allow the gaslighting to continue, and they don't push back. I have yet to see anyone in the media push back against these claims other than maybe Billy Bush, who does some stuff on Extra, but I haven't seen a single journalist push back, not one. And that's what the work is of the press. They are supposed to ask questions. They are not supposed to be merely the PR vehicle for a celebrity to make them richer. We're supposed to be about holding people accountable, okay? But moving on, yesterday, I told you about what was going on with the case and how Stephanie had requested a motion to compel, and I said yesterday that I felt as if everything that she was doing was so early that she genuinely shouldn't have been filing this, that she was doing this in order to get in front of the judge to remind them that she has a motion to dismiss some of you in my comments. I was reminded that she actually requested a stay on discovery, so you thought that this request was insincere because it's like, well, what do you want, Sloane? You want to remain on discovery, or you want to be forced, which is it, do you want to remain on discovery, or do you want to be forced? And then we discussed how she raised the wiretapping materials. Okay, well, they reacted with a letter to the judge as well. It's quite brief here, and I'm going to attempt to be a good reader, not read too quick. I know some of you don't care for that, I read, but I do this for those who do. So it says the Sloane parties have notice of the claims against them. And I want to say this before I start sharing. This is that a lot of the things I talked about yesterday in my video are actually mentioned. So I either have a good pulse on the legal side of things, or they pay attention to me. But I feel like I'm just possibly making good assumptions based on what I'm seeing, based on my experience of reporting cases. The false premise of the Sloane party's motion is that they purportedly lack notice of the Wayfair party's claims against them. However, the party's amended complaint alleges that the Sloane parties made statements to third parties, including the New York Times, to the effect that Belden is a sexual predator who sexually assaulted Lively, and that Belden retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. Pretty clear. The amended complaint alleges that the Sloane parties made further false statements in response to media inquiries concerning Lively's wrongful accumulation of power over the production, how she did so, i.e., the false accusations of sexual misconduct, and the resulting turmoil. So, this is really one of the first times we see them say she's using false allegations of sexual misconduct in order to gain power, and specifically, the Sloane party stated to the Daily Mail that reports of a power struggle on set were 1,000% untrue. Your info is totally off. "You have it all wrong," and "Your reporters are so wrong." Instead, the Sloane parties seeded false information to cast Baldoni rather than Lively in a false light. The whole cast doesn't like Justin. Nothing to do with Blake. They, Wayfair, are panicking as the whole cast hates Baldoni. I don't know a lot about the false light claim, and I don't know about what defamation covers in terms of if it doesn't have a criminal aspect. If it's genuinely just that they lied and told a lie about something that isn't even that terrible, you know what I mean? I suppose I'd have to examine that element of defamation, but my take on what their claims of defamation against her are is that she deliberately misled the media about what was going on set in order to deflect it onto Justin and make it appear like he was the problem rather than Blake, playing a game of misdirection, and she was doing it in order to cover for Blake. That's how I'm seeing it, okay? And whether or not they will be defamatory, I have no idea. But if she's doing it to place a false light upon him, that would make sense because you're trying to illustrate that he's a different person than who he is. There's a little point here at the very bottom. It's a footnote, and this is about those wiretapping calls. The Sloane parties falsely alleged that Melissa Nathan serendipitously listened to Mrs. Sloane's phone calls in violation of California's wiretapping statute, California Penal Code 631. Amazingly, 2 sentences later, the Sloane parties acknowledged that they lack knowledge about whether the Daily Mail or Nathan added the other to a private conversation without Miss Sloane's consent. In other words, the Sloane parties have no knowledge that Nathan did anything inappropriate. In any event, and putting aside the recklessness of the allegations, the conduct described by the Sloane parties does not constitute wiretapping under the cited statute. I think they're just trying to put that to bed because they don't bring it up as a claim. The amended complaint also alleges that they made 1 or more statements to third parties, including to the New York Times, to the effect that Wayfair parties engaged in, permitted, and/or failed to prevent sexually inappropriate conduct toward Lively and others, and retaliated against Lively for reporting the alleged misconduct, including by propagating false narratives about Lively for the purpose of damaging her image and reputation. The pleading alleges that the Sloane parties told the New York Times a false and damning story about an insidious PR sabotage operation deployed as revenge for sexual harassment complaints with the knowledge and intent that the newspaper would publish the false story, and that the Sloane parties propounded a false smear campaign narrative designed to destroy the Wayfair parties. You know, I feel like in that New York Times article, I'm going to look this up, I feel like there was a statement by her team in this article. In the article, BlakeLively issued a statement hoping that her legal efforts would reveal sinister retaliatory tactics employed to try to intimidate people who speak up about wrongdoing and assist others in avoiding being treated in a similar manner. She also unequivocally denied that she or her staff distributed negative information about JustinBaldoni or Wayfarer Studios. The piece observes that her legal documents contain passages from thousands of text messages and emails obtained through subpoena in what is increasingly being labeled a sham suit. The pieces were apparently vetted by the New York Times. The article, however, draws extensively on the CRD complaint and strangely does not reproduce the full messages. Rather, it acknowledges the texts were edited for length and context. This creates transparency issues, as only selected quotes were given instead of entire conversations. Furthermore, there is no direct quote from Leslie Sloane, Lively's publicist, though she would have had a hand in arranging the New York Times piece. The arrangement of press interviews and appearances is usually Sloane's domain, indicating she probably assisted in arranging the publication of the article. The article also answers objections by the other side of interrogatories that they claim are too broad, creating additional procedural concerns in the case at hand. And they make a really interesting point here because interrogatory number 3 says, "Identify each person you allege communicated with regarding the Wayfair parties. As set forth in the Wayfair parties' formal responses and objections, this interrogatory is not limited to matters that are relevant to any party's claims or defenses." So Sloane said that they were trying to say she was being sued for defamation and false light based on unidentified conversations she allegedly had with an unidentified person at an unidentified time using unidentified words. but they say that it's not limited to identifying the names of witnesses with knowledge of information relative to the subject matter of the action as required by this, and that it exceeds the scope of Local Civil Rule 33.3. They also discuss how she did the narrowing of it to seek to identify the people with whom they communicated. What's interesting is she wants to compel JustinBaldoni, but JustinBaldoni, the person, is not Wayfair. So if she's asking the Wayfair parties for information about identifying people, it would be weird to ask Justin then, right? Like, you can ask the company, but maybe not Justin. And they do make this point here, that the Wayfair parties responded to a different interrogatory seeking broader information. Interrogatory number 1 requests the identification of any person believed or known by you to have any information or knowledge concerning any event, fact, matter, act, allegation, or issue included in or raised by the complaint or amended complaint, and they incorporated by reference their initial disclosures, which she admits disclosed over 150 individuals and entities that had information about what Sloane, Blake, and Ryan had done. 150 people, that's a lot of people that know what happened or have information. They also say that they didn't waive their local civil rule objection to interrogatory number 3, and they claim she used a bunk legal case for her argument as to why it should be compelled. Their argument is that under Local Civil Rule 33.3a, she is outside the bounds of what she can do in discovery for interrogatories, and they have a right to object under that, and it too broadly seeks the identification of anyone with whom the Sloane parties communicated regarding the Wayfair parties. And then as far as interrogatories 4, 5, and 6, they say it's improper because each alleged defamatory statement, each malicious story portraying Baldoni as a sexual predator, each of the stories critical of Baldoni, these are impermissible contention interrogatories that exceed the scope. They say in their plea for leave to exceed Local Rule 33.3a, the Sloane parties disingenuously contend that they need a basic roadmap of the claims against them to prepare for their defense. However, as detailed above, the amended complaint specifies the media outlets with whom she conversed, approximately when she spoke to them, and the words she used during those conversations. To the extent the Wayfair parties have specific knowledge of facts relating to her defamatory statements, if she has engaged in other defamatory conduct, she will not need to guess which of those are defamatory because she's the one who made the statements. And as for her need for the news articles that they allege are defamatory or otherwise actionable, she will obtain them in document discovery. Did I not say yesterday that she knows who she spoke to, and she knows what she said, and to whom, and when? She has all of the emails and texts on her own end. The other side raises the inconsistency in BlakeLively's requests for information she already has. They claim that she already has access to the text messages and emails from her own end of communication, and thus knows precisely whom she communicated with and what was said. As they pointed out, they will give the applicable documents during discovery, but it is unreasonable for her to ask for information she already has. It's a tactic that comes across as insincere. Further, in relation to her request to see evidence pertaining to an amended complaint, the problem is that the amended complaint has yet to be filed, so her request comes too early and lacks legal standing. They haven't filed. They said the second amended complaint does not exist, may never exist, and of course has not been filed. The Wayfair parties objected on the grounds that the request seeks information protected from disclosure by the attorney-client privilege, work product doctrine, and any other applicable privilege. They further objected to the request as premature. Like I said, it was premature because a second amended complaint does not exist. The case cited by the Sloane parties stands for the unremarkable proposition that a party must produce documents referenced in its pleading. If a second amended complaint is filed, they will produce all non-privileged documents relevant to the claims, located upon a diligent search, to the extent that such documents have not therefore been produced, including any document referenced in such currently non-existent pleadings. I really like how they're pointing out that she's asking for something that they haven't filed, and they're really driving home the fact that she's asking for something that they have not filed. And the last part of this is exactly what I said yesterday. We respectfully request that the court deny the Sloane party's motion to compel. Unfortunately, the Sloane party's true purpose in filing the motion is not to compel discovery, but rather to re-argue their sub judice motion to dismiss, which they anticipate will be denied based upon the court's denial of their motion to stay discovery pending their dismissal motion. Did I not say that they were trying to get the judge to remember that they filed for a motion to dismiss because they have a feeling that it's not going to be dismissed? And if you were going to compel someone and you believe you're going to be dismissed, why are you trying to get documents? The only reason you would be filing a motion to compel is if you knew that you were not going to get your motion granted. Only reason you would be making a motion to compel is if you knew that you were not going to receive your motion granted. Here is some information for those of you that are confused. What are the rules for judges deciding motions to dismiss? The current timeline for this litigation is they are supposed to go to trial in March. The chances that this will go to trial in March are slim to none. Cases hardly ever make it to trial at the initial date that is assigned for a trial in federal court. They are usually extended years. It takes years to make it through the federal court system, and it takes years to make it through any state court system with a civil case. So to be irritated after 4 months is extremely early because this case could be ongoing for 3 or 4 years. That's the reality, and it may be frustrating to some of you, but that's the reality if they don't settle. And so what do judges have? What's their timetable? Well, under the federal rules, a judge must either make a ruling within 6 months on a motion to dismiss or schedule a hearing on something not yet decided within 6 months. Sometimes on motions to dismiss, they will hold a hearing so the sides will be able to argue. In this instance, it does not look like she is going to do, or they are going to hold a hearing where each side can make their best argument to the judge. So if that's the case, he will decide in 180 days. Leslie completed hers, and it was briefed fully, I think, mid-March. So she's a month and a half in. She might be waiting 4.5 more months, and many federal judges do not rule until they plainly have to because judges are busy. And unfortunately, in the world of the Southern District, this of New York, they have way larger cases to contend with than this, right? There are criminal cases that these judges are sitting on and are working on. Actual real issues that are affecting people that are victims of crimes and not civil cases. And those cases that are the most emergent are those that end up getting fast-tracked. And criminal cases, since they have a speedy trial guideline in federal court, have a tendency to be quicker than civil cases and precedence over civil cases. So with that said, Judge Lehman is likely probably presiding over numerous cases currently. Many those that are much more significant than this have cases that he must be ruling on the right, so he's likely got motions to dismiss from other cases that he hasn't even read yet, so for her to say that it needs to occur now is absurd. And I would estimate a motion to dismiss, will not be decided until the absolute last moment, because they will utilize the amount of time they are allotted often, and not a day earlier. That has 100% been my experience in both federal court and state court. Okay, so what I appreciate here is that they're highlighting the things that I stated, and I don't know if they watched me, perhaps I actually got something correct here, but that she knows what she stated. It's highly premature. She's requesting things from something that hasn't been filed because she's panicking, obviously, and that she wished to re-argue her motion to dismiss. So when something is sub judice, which means that it's being considered by a judge. And so technically they shouldn't be using this motion to compel to re-argue their motion to dismiss, which is another reason why it's being raised. He hasn't ruled. They shouldn't be raising it in another filing until it's ruled, and they shouldn't be re-arguing their motion to dismiss in another filing again. And if this is what I think they're doing, and they think what they're doing, judges don't appreciate that at all. It's an abuse of the court process and the resources. So while Blake and Ryan and her PR are all over the news, attempting to make you forget about what's going on, I'm going to remain focused on what's really happening, and I'm not going to get lost in the lies of BlakeLively and Ryan Reynolds, the two largest narcissists in Hollywood. And I'll just say they pay people, they settle with people. And people are obviously afraid of them because this is what they do. And when people do things like this, the media either only gives positive reporting or they don't, or they spike the negative because they don't want to contend with the vitriol. I watched Todd Chrisley do this at his criminal trial. No one in the MSM was covering his case because Todd would threaten to sue everybody, and nobody of these outlets wanted to be sued by him, so they would just literally only publish fluff pieces because he would threaten them. And if I were to speculate, that could be going on here, so just take the source of where you're obtaining your information on BlakeLively and Ryan Reynolds. Alright you guys, let me know what your opinions are in the comments down below. Be sure to give this video a thumbs up. Be sure to subscribe to my channel if you haven't yet subscribed and hit the bell so you never miss a video. Thanks so much for watching. Bye guys.